Hello, I'm Amit Sharma. Welcome to this podcast where I discuss Section 21 notices. Over the years, the amount of complexity that landlords have had to face has increased quite dramatically. There are now a number of things that need to be 100% correct before you can start serving a valid Section 21 notice. So usually, before the start of any tenancy, you would provide the tenant with a gas safety certificate. You would then also provide the tenant with the energy performance certificate and recommendation report, and note that the EPC would have to have a minimum rating, otherwise you're not going to be permitted to rent the property. You would also need to provide the tenant with the right to rent checklist, which is a booklet provided by the government. You would also need to provide the prescribed information with regards to tenancy deposit protection schemes. A point to note about the amount of deposit: from the 1st of June 2019, there is going to be a cap of how much deposit can be taken by a landlord. Further details are obviously going to be available online. Do also note that from July 2020, electrical safety certification is probably also going to be required, and this will extend to all tenancies, I believe, from the following year. Now, I am assuming that you are a private landlord looking to take possession of a property that is not a house in multiple occupation. I'm also assuming that your tenant hasn't made any complaint that is going to restrict your ability to serve a Section 21 notice. So as you can see, it's a number of things. Now, if there is anything missing at the time where the tenancy is in existence, then you will need to provide those missing documents to the tenant and provide some evidence that you have provided the documents to the tenant. Now, what I recommend is you go onto the HMCTS website, which is a court's website, and download form N215. It's normally available as a PDF document, and you can use that as a format for certificate of service. So once you provide your document, you complete the form and sign it, and keep that form with you with a copy of what you've provided. Some of you may have a tenancy that's been sort of cut, paste and copied over the years, and do ensure that terms in the tenancy are fairly consistent, because otherwise there's a good chance that if there's some confusion, the judge will order a hearing on the matter of confusion. A common trap for many landlords is that they don't follow the procedure that's set down in the tenancy agreement. Now, if the tenancy agreement says that you must provide the document in a particular way to the tenant, so that will include notices. For example, if the tenancy says that you must provide the document by registered or signed for postage, then if you send the document by personal service, or if you send it by first-class post, it's not going to be validly served in accordance with your agreement. I would also recommend that you familiarise yourself, if you're not familiar already, with the Form N5B, which is the Accelerated Possession Claim Form. That will sort of give you an idea of the sort of evidence that the court is going to require. Broadly, it's going to follow, in some senses, what I've said. I haven't talked about houses in multiple occupation, which obviously has a few other things and a few other hurdles that need to be fulfilled. If you think you need some help or advice, certainly get in touch with us. We hope you have a great day. Thank you for listening.